I did a video recently about service of process. I mentioned service of process. And what that means is you sue somebody. You hire an attorney, they draft a lawsuit, they file it with the court. The court then hands it back to them, a copy of it along with a summons. And then you have to serve the defendant with a summons and the complaint to let them know they're being sued and how the lawsuit looks and all that. And the process of getting someone served, okay, is a whole thing. You've heard of process servers. I'm not going to get heavily into the requirements for the service of process. It varies wildly from state to state, but generally speaking, a person's got to get served with the complaint and the summons to let them know they are in fact being sued. And so I mentioned in a kind of an aside that there can be problems with service. And we've heard these horror stories before about people saying, next thing I know, my wages are being garnished and I never knew I was being sued. And so what happened was somehow they got sued. They never knew about the lawsuit. A default was taken against them. A judgment was entered, and the judgment sat there for a while, and then now their wages are being garnished or whatever. And it can happen. There can be flaws in the system, and they can happen one of a couple of different ways. But the court rules say, here's what you must do to serve somebody with a lawsuit, a summons and complaint. Some courts will actually say, if you sue somebody in our court, you've got to have one of our personnel serve the lawsuit, because that guarantees the court would know that if our people did it, we know the person got served. But most courts simply say you can follow the court rules, and the court rules say that you can hire a process server, and a process server can be any competent adult who's not a party to the action can go serve somebody. And I knew a guy once who, when he heard that, said, wait, I can become a process server? Yes, you can. He became a process server, and he had business cards printed up and said he'd go out and serve people for you. He served a lot of things for me, and he was very, very good about it. But on the other hand, we've heard stories where process servers can't find somebody, simply take the summons and complaint and toss it and go, yeah, I served them. So if you look in Michigan, the back of the summons actually has a return of service that's filled up by the process server, and it says, did you serve this person? You have to sign it and so on. But it also says, where did you serve them, what time? And so obviously, if you later say, I was never served, they're going to pull out the summons and go, well, this person claims they served you at this place and time. And that, you might say, but Steve, they can make up stuff, and it's his word against theirs. Oh, you'd be surprised. And so I had to tell you the story, because I remember when this happened, and the story is almost 20 years old. It is literally 19 years old. It happened back in 2005, okay? So I remember this happening, though, because remember, I've been an attorney in Michigan since 1991, and I actually knew the attorney involved in this story. And so the headline of the story I'm going to read to you says, Attorney Cops to Plea Agreement. Attorney Cops to Plea Agreement. Cops, there's a verb, of course. And Jason Alley wrote this story for the News Herald back in 2005. An attorney charged with falsifying hundreds of court records was fined nearly $150,000 and put on 6 months house arrest after a plea deal reached with prosecutors. The attorney was also put on 2 years probation, during which time he's forbidden from practicing law. So now the story is unclear if the state bar took action against him, because they could suspend him, but it looks to me like part of the plea deal was simply, I will voluntarily stop practicing law, but again, I don't know for certain. The attorney was put on 2 years probation, forbidden from practicing law. He was in Southfield, and he pleaded no contest to 136 counts of criminal contempt of court. 136 counts. Now, he was originally charged with 308 counts, but they reduced that during negotiations. Now, keep in mind that the no contest plea is not an admission of guilt, but it's treated as that for sentencing purposes, but it changes an effect if he gets sued. That's the key here. Special prosecutor said he's happy to sign off on the agreement rather than sit through a lengthy trial that was set to begin shortly after this deal was reached. The special prosecutor said when an attorney gives up his right to practice law for 2 years and faces house arrest for 6 months, these are very serious charges. When you and I are able to leave our residences freely and do what we want to do on weekends, this man isn't going to be able to do that for several months. Now, the attorney ran a firm which was known as a debt collection firm, and I encountered him on more than one occasion. Never had trouble with him because I was always defending lawsuits that my clients were served with. And so he was very well known. When he was hired to go after someone to collect an overdue bill, He's accused of filing fraudulent court documents saying that he had notified the person as to when he or she was to appear in court when really he hadn't. And I remember reading other stories. And a lot of these cases are being filed in the same court. Same court. Same court. Stacks and stacks and stacks of lawsuits. And for whatever reason, one of the judges became suspicious at the percentage of the lawsuits that this one attorney is filing that resulted in defaults. Because a lot of debt collection lawsuits do start with a default because someone gets sued and they go, I owe the money. Why defend it? Just who cares? But a larger proportion of this guy's were defaults. And for whatever reason, the judge looked at the return of service and noticed that many of them had the same date and time on them, saying that I served this person on this day and time. I served this other person at the same day and time. I served a person over there, same day and time. And so somebody had gotten lazy filling out the returns of service using the same date and time for all these different services that supposedly happened all over the place, which is physically and mathematically impossible. And so the judge started looking into this. And so then the judge went and pulled every single summons with a return of service that had been filed and signed by this attorney and saw patterns that did not make any sense. And so he called the attorney in on the carpet, so to speak, and said, we got a problem here. And I remember when that hit the news, and I'm like, oh, I know that guy. And the judge in that case, I believe, found quite a few of these. And at one point in time, there were 308 counts. I just don't know if all 308 were in the exact same court or not, because when this hit the news, other courts started looking into it. But as I mentioned in the video I did recently, a lot of debts are the result of loans gone bad, and the lender says, we have the right to sue you in this one court if you default. And so that one court is where most of this guy's lawsuits were being filed on behalf, at least, of that one client. So when the person who was served or not served didn't appear in court, the attorney sought and often got a default judgment from the judge, allowing him to collect the past due money by garnishing person's wages and so on. In some cases, he's accused of seizing people's vehicles and tax returns before they even knew they were being sued because they never got served with the summons and complaint. Now, this man's attorney blames the irregularities on a process server who was hired by the firm to deliver those notices. So he says, look, the attorney filed a process server. The process server went out and did all this stuff. However, the attorney admits that the attorney charged did do something wrong because he allowed someone else to sign his name to the forms, giving the impression that the attorney had reviewed them when he actually hadn't. And that right there, I believe, is off by a little bit, because if I serve a summons and complaint, I sign it. If someone else serves a summons and complaint, they sign it. So if someone else serves a summons and complaint, they don't sign my name, they sign their own name. And so if this attorney lets someone else sign his name to a document and he submits it to the court, that's on him. That is on him. Absolutely. If you sign my name with my permission to a document, I'm on the hook for that. And so I can tell you that there was a time on more than one occasion where I've asked a secretary of mine who I trust very, very much to draft a letter while I was out of the office and send it and sign my name to it. And I'd have her read it back to me, and I said, sign my name to it. She'd say, you sure? Yes, sign my name to it. And now I've seen attorneys who will say, dictated but not read, indicating that there might be an out here if there's a big mistake in it. But the point is, if you authorize someone to sign your name to something, you got to be real careful about that, because you might wind up pleading guilty to 136 counts of criminal contempt, because those are documents, legal documents being filed with the court. So his attorney says, my client categorically denies any knowledge of any falsification of those documents. If the process server did not make those attempts to deliver, he didn't know anything about it. Of course, within minutes of leaving the courtroom, the man was met with the court's probation officer, who will set up having a monitoring device installed on his body presumably around his ankle because that's what's in fashion these days, to ensure he doesn't leave his house. As part of his plea deal, he's also ordered to pay $68,000 in fines and court costs, $43,000 in restitution, and $32,000 the cost of prosecuting the case against him. And so I think that added up to about almost $150,000. And I'm wondering about the restitution being to people who had money or wages or cars taken who had never been served with a lawsuit. So the prosecutor said he was most pleased with that, knowing the people who had never had an initial day in court are now being reimbursed money that was taken from them. We just don't know if that's the full amount of everybody, but the attorney says, the prosecutor says, every penny collected from these folks is going to be returned to them. This is going to go a long way to ensure this never happens again. So in light of the seriousness of the charges against the attorney, the State Court Administrative Office last month directed all Michigan circuit and district judges to review past cases filed in their courts by this attorney. That's the kind of thing where, as an attorney, it sends shivers up my spine. I'm not sure how many lawsuits I've filed in my career, but it's quite a few. And if I ever did something where they actually sent out a notice and said, please pull every file Steve Lehto has touched, we're a little concerned about that. Oh my God. I mean, I can't even imagine that. Judges were told to look for a variety of things, including questionable signatures, multiple filings being served at the same time and date to people in different locations, unreasonable interest charges, and garnishments made against people not named in cases, which is another story altogether. The findings of that probe have since been turned over to the Attorney General's office and are being investigated by the department's Consumer Protection Unit. Meanwhile, several of his victims have also signed onto a class action lawsuit filed against him in Oakland County Circuit Court. The attorney handling that was not available for comment at the time of press, but his attorney did confirm that a major reason that the attorney at the heart of this pleaded no contest is because that can't be used against him as evidence of liability in the civil case. And I don't remember ever hearing anything more about the civil case in that, or whether or not anything else came regarding the investigation into the other courts and filings. But I do remember this story hitting the news. And I've got friends who do nothing but defend debt collection actions. And this guy at one point in time filed quite a few of those. I don't handle those cases, so, that's not how I got to know the guy or know who he was. But I remember when the story hit, and then when you start hearing about how it fell apart, how it unraveled because a judge is going, wait, he served this person, this person, this person, this person, this person, this person, all at the exact same date and time. Now, he says it was a process server making that mistake or pulling one over on him. But again, a process server can file the return of service on behalf of themselves. They don't sign the attorney's name normally. Like I said, I would never let a process server sign my name to a document because I would know that puts me on the hook for the fact that that person was served properly. And you might say, but Steve, how do you know that your process server went out and got the right person? Well, normally I'd give the guy one job at a time. And I'd say, go serve this person. And he'd say, can you tell me anything about him? And I'd have my client describe the person and where they are and what they look like and what kind of car they drive and that kind of thing. And never had anyone come back and say, I was not served. Never happened. Except I did have one person actually tell their attorney that they weren't served. And I've mentioned this before in a video I did years ago. I used to occasionally serve those myself. If I was bored and I had time and I didn't feel like calling up my guy and spending the money on him, I'd go serve it myself. And I served at least two people that were comical in the sense of how it went down. And one of those guys told his attorney and said, I wasn't served. And the attorney said that to me, and I said, funny, how do you know he's being sued? And the attorney goes, well, I think he found the papers someplace. I said, oh, he found them in his hand when I handed them to him on his front porch. And I give the address and I describe the guy. And I go, by the way, his wife was standing right next to him. I describe her and what she was wearing. I said, do you really want to go into court on this? If you want to, we can. It'll be a swearing contest. I'll tell the judge about how I served the guy. And your guy can come into court and say, I wasn't served. I found the papers someplace. And by the way, it doesn't matter what happens because the judge is going to go, well, you're here now. So I hadn't defaulted the guy or anything. The guy just turned these over to his attorney and said, I just found these someplace. So anyway, I just thought I'd talk about that because this is one of the wildest stories I've ever heard about allegations made against an attorney. But it happened, like I said, 19 years ago, but it's one of those stories that it's hard to forget once you hear about it, especially if you've dealt with the guy in the story, as I had probably 20, 21, 22 years ago on unrelated cases. So attorney cops to plea agreement, old story from the News Herald. Story came out of Lincoln Park, Michigan. And that's why it's going straight to the vault, because it is not a recent story, but it's something that just kind of sparked my memory. Questions or comments, put them below those. Talk to you later. Bye-bye.